which the maritime industry is facing in the pandemic restrictions, and to understand how we can overcome these challenges. Today, as speakers, we have with us, as our keynote speaker, Justice Shoman Shen. Then we have the Honorable Judge High Court Calcutta. Then we have Mr. Tilak Kumar Bose, Barrister and Senior Maritime Counsel, High Court Calcutta. Mr. David Morris, a partner of Holman Fenwick William LLP, London. And then Shri Vineet Kumar, Chairman, Kolkata Port Trust, with us. Now, before we start the proceedings, I request my colleague Shornali to give a tech briefing to the participants. Shornali, can you take it forward, please?
Thank you, Romit. Good evening, everyone. For the ease of listening to the esteemed panelists, we have taken away the muting and unmuting rights from the participants. In case you have any questions, kindly put in your question in the chat box along with the speaker name who you wish to ask the questions to. Also, we would request you that apart from the speakers, kindly keep your videos off for a better bandwidth. Thank you very much. Over to Romit. Thank you.
May I now request Captain S.B. Mazumdar, the chairperson of the Shipping Committee of the Bengal Chamber, to kindly deliver the welcome address. Sir, over to you.
Thank you, Romit. Good evening to everybody, all the delegates who are logged in. It's a good number, I see, 169 plus. Generally, there's a tendency as the session continues, more people join in. I welcome them as well. A warm welcome to all the delegates. A warm welcome with due respect to all the speakers who are also spared their time, and we'll try our best that those who are in a hurry are probably allowed to speak earlier by our moderator, and I'm sure everybody will be able to participate the way they had anticipated. With these few words, sir, I would like to first extend the Bengal Chamber's warm welcome and respects to Honorable Justice Soman Sen, Judge of the Calcutta High Court, who will give the keynote address. And thereafter, we have three excellent speakers, very renowned and known to everybody. Mr. Tilak Bose, the very, very senior barrister of Calcutta, and he is also an expert in the maritime law. Mr. David Morris is a partner of Holman Fenwick William, London, and hi David, and he's speaking from London. I presume it's about 5:30 in the afternoon now, and I do hope it's not raining and he has a bright sunshine over there. And the last speaker is, of course, our well-known Mr. Vineet Kumar, the chairman of Calcutta Port Trust. Sir, I thank you for having agreed to speak on this occasion with us, just on a short half-a-minute talk with you. Thank you, sir. Welcome to all our speakers. I would like to briefly, don't want to spend too much time because it's more important to listen to the speakers than listen to me, which you have been hearing for the last 7 years. I would like to briefly say about Bengal Chamber. It's the oldest chamber in the country, and it is about 167 years today. They have several committees amounting to some 40-45.
Yeah, Mr. Luna, have you logged in?
Ramit, mute yourself.
Sure, sir.
Bengal Chamber has a lot of committees, more than 40 committees plus, covering the entire industry, agriculture, finance, banking, tourism, shipping, logistics, you name it, they've been there. Apart from just holding seminars and all, they are also involved in a lot of other activities. And recently, they have also helped the government of West Bengal in aiding financially and physically, helping with food and other items to those who have suffered in the recent cyclone which devastated West Bengal, especially Southwest Bengal. So chambers have a lot of activities, and Shipping Committee is one of the committees which is very prominent and very active. We have a very strong committee. I headed as the chairman for a couple of years. We have very, very senior people in this committee from the industry like steel, Tata Group, the container freight stations, port, forwarding institutions, clearing and forwarding agencies, transporters, logistics players, the whole gamut are represented in the shipping committee, and because of whom we are able to have a lot of ideas, and from the feedback we get from the various programs that we have held, the audience also suggested to us on many occasions with a subject, and we take it on from there. So every year, this committee of ours, we organize two major events. One is an annual event, which is a full day event with a very important topic, generally which becomes a current topic. It could relate to port, it could relate to shipping, it could relate to coastal shipping, it could relate to logistics, customs clearance, EXIM trade. Most of these programs and subjects have been already covered, but there are many more to be covered in the years to come. Other than this full day's program, we also have a half day session, which we call a workshop. That is more or less, it's an educative kind of a program that we have, which it's either an educative or it's a training program. This particular webinar today on evaluating challenges before the maritime industry under the pandemic restrictions is also one of them. As you all know, the whole world is suffering from this pandemic, and there's a big question mark on the future for every industry, not just shipping. Of course, shipping is extremely affected. So we will learn a lot from these three speakers, and the Honorable Chairman, Calcutta Port, will, with his expertise, give us his views on how ports, shipping, logistics, forwarders, etc., should go ahead and look forward to future actions. With these few words, I think it's time now to start the session. And I would like to say that this session of webinar, the brainchild has been Mr. Shubhajit Ray, who's the partner of Victor Moses and Company, which is a leading law firm headquartered in Calcutta. He is the one who came up with this idea, and our committee debated it and immediately agreed that this is one of the best programs which will be helpful to all the people on the field in every sector of the maritime industry. And he will also give the details of the speakers and their experiences. Shubhajit, may I hand over to you to take the session forward. Thank you.
Thank you, Captain Mazumdar, for your very kind words. I believe the beginning of 2020 has been unprecedented in the at least more than a few centuries that we have, because of the pandemic that has taken over the entire world, its economy. The topic which we have today here is very relevant, not only for the industry, but also for the legal fraternity. Evaluating challenges before the maritime industry under pandemic restrictions. We will have a look at this issue, which is staring at us. At least in the next 2 years to come, we will be facing these challenges. And most important part of these challenges would be the issue of force majeure, of avoidance of contracts and frustration of contracts. There are many stakeholders in the shipping and maritime industry. There would be ship owners, ship builders, charterers, cargo interests like importers and exporters, the insurers, the brokers, container agents, stevedores, handling agents, labor suppliers, very importantly, the ports, and eventually the customs. The entire industry is well knit with these participants and stakeholders, and each of them stand to either gain or suffer with the fate as to how the pandemic challenges are overcome and countered. Now, when a charterer, he takes a vessel, he is usually almost in every occasion asked to take the vessel to a safe port. When a vessel reaches a port and is quarantined or unable to immediately commence operations, it faces a lot of issues, one of which is demurrage, a critical one, but just one among many. These issues, ultimately, they boil down to a legal dispute, and a lot of economics depend on how these issues are to be resolved eventually. We have with us a really important people, a set of people who are the best in the field and from whom we can learn and from whom we can be enlightened as to the basic concepts and also acquire key guidelines as to how we can meet and counter these challenges for everyone's benefit. I first request Justice Soumen Sen to deliver the keynote address. Justice Soumen Sen is a senior judge presiding over Division Bench of the Calcutta High Court. He has had an illustrious career as a lawyer, and now he is one of our favorite judges of the Calcutta High Court. Justice Sen, may I request you to please start the keynote address, and I hand over the session to you now, sir.
Thank you, Shubhajit. A very good evening to all. I feel honored for the invitation extended to me by the Bengal Chamber. The subject matter of today's discussion is extremely relevant as the global outbreak of the novel coronavirus has caused breakdown of trade and commerce. It has affected every citizen, trader, or in one way or the other. It has affected countries socially and economically. It has become an existential crisis. On the 11th March 2020, WHO officially declared that the novel coronavirus of 2019 a global pandemic. It has resulted in the lockdown of various nations with many non-essential services being ordered closed in order to mitigate the spread of the virus and save human lives. Though ports largely remain open to cargo vessels, the pandemic has impacted the shipping industry due to shortage of crew, the closure of shipyards, delaying necessary refit works, and restrictive measures being implemented by certain ports in order to ensure the safety of their personnel. As supply chains break down and contractual deadlines are missed, parties started contemplating how to mitigate their exposure to their damages being incurred as a result of this unprecedented virus. The question that often arises under these facts would be that whether COVID-19 would be considered as an unforeseeable or unpreventable event, a force majeure, which I'll refer to as FM in brief short, and whether parties may rely on such principle either to deny their liability or mitigate their liability for damages. Now, FM is a principle of law which is applied as a defense to performance and discharge of contractual duties and obligations, and entitles a party to refuse liability for damages caused arising out of such non-performance by reason of unforeseeable or unpreventable event which has rendered the performance of an obligation impossible. This has been the views consistently held, applied in all the jurisdictions. The doctrine has its origin in French law, which relieves a promisor from the responsibility and liability arising out of non-performance in certain unforeseeable and irresistible circumstances. The English law now has also recognized the same principle, thereby diluting its earlier stance of the absolute sanctity of the contract. The test now applied is to find out if the contract has been frustrated due to a radical change in the obligation. The doctrine of impossibility in the common law of contracts excuses performance when it would be physically and commercially impossible by one or both parties to carry out its contractual obligations due to set of circumstances arising after the formation of the contract. If the doctrine is successful, the contract is rescinded without.
Shomrit, you have to request Shoman to be on
Just-
mute.
Yes, I believe we are having a technical snag. I'll just request Justice Soman Sen to please. Yes, I think, yes.
Yes, sir,
Sir,
you're audible.
Sir, you are now. It's
It went
perfectly
on
fine
mute.
now.
I was saying that I refer to Section 56 of the Indian Contract Act, and I said that this section states that on occurrence of an event which renders a performance impossible, a contract becomes void thereafter. In contrast to the English law, where frustration of contract is decided on the true construction of the contract, the statutory provision in Section 56 lays down a positive law and is exhaustive on the subject. In the Indian context, it has been settled by a long curtain of decisions that when the parties have not provided for what would happen when an event which renders a performance of the contract impossible, Section 56 of the Contract Act comes into play as it excuses impossibility and renders a contract void. The expression FM is not a mere French version of the Latin expression vis measure. It is much wider and undoubtedly a term of wider import. Difficulties have arisen in the past as to what could be legitimately be included in FM. Judges have agreed that strikes, breakdown of machinery, which though normally not included in this measure, are included in FM. An analysis of rulings on the subject shows that where references are made to FM, the intention is to save the performing party from any consequences over which he has no control. This is the widest meaning which can be given to FM and laid down by our Supreme Court in Dharanraj Govindram versus Haji Kalidas. In Shottabrata Ghosh, the Supreme Court has stated that for deciding cases in India, the only doctrine that we have to go by is that of supervening impossibility or illegality as laid down in Section 56 of the Act, taking the word impossible in its practical and not literal sense. The judgment reiterates that it must be borne in mind that Section 56 lays down a rule of positive law and does not leave the matter to be decided according to the intention of the parties. In a fairly recent decision in Energy Watchdog versus CERC, the Honorable Supreme Court has stated that the FM occurs divorce a contract. It is dealt with by a rule of positive law under Section 56 of the Contract Act, thereby reaffirming and reiterating the principles enunciated by the earlier decisions. The word impossible does not mean physical or literal impossibility. It may not be literally impossible, but may be impracticable and useless from the point of view of the object and the purpose of the parties. If an untoward event or change of circumstances totally upsets the very foundation upon which the parties entered their agreement, it can be said that the promisor finds it impossible to do the act which he had promised to do in the context of a defense of frustration on the ground of freight charges and price escalation in coal, it was held that mere incidence of expense or delay or onerous is not sufficient, and there has to be, as it were, a break in identity between the contract as provided for and contemplated and its performance in the new circumstances. The court here applied the radically different test and has observed that since the subject matter of the doctrine of frustration is contract, and contracts are about the allocation of risk, and since the allocation and assumption of risk is not simply a matter of express or implied provision, but may also depend on less easily defined matters such as the contemplation of the parties, the application of the doctrine would be a difficult one. The possibility of rise in prices in that case of fuel was a risk known to the parties. Now, this would be a very important factor when I go to my concluding remark. Now, the kinds of events that are typical of FM would include earthquakes, floods, war, restraint of government, and strikes. If the contract includes a FM clause, these need to be carefully analyzed to determine whether terms included are wide enough to cover defaults caused by a pandemic such as COVID-19. FM clauses are triggered by the occurrence of an unforeseeable event like COVID-19 at the time or during the performance of the contract. The Bombay High Court on 8th April 2020 in Standard Retail Private Limited versus Messrs. GS Global and others is possibly the first case since lockdown where, considering an application for interim reliefs against the invocation of letters of credit, it was held that the lockdown cannot come to the rescue of the petitioners so as to resile from their contractual obligations, as the lockdown was temporary and for a limited period and cannot be an excuse for not making payment. That appears to be the basis of the judgment, apart from the fact that the letter of credit is an independent transaction with which the bank is not concerned, and the bank is not concerned with the underlying transaction between the buyer and the seller. And the FM clause was in that case made applicable to the respondent number 1, who had already performed his discharge his obligation. The High Court did not find the performance objectively impossible. However, the Delhi High Court in Halliburton Offshore Services Inc. versus Vedanta Limited and another opined that the countrywide lockdown prima facie in the nature of FM, such lockdown is unprecedented and incapable of having been predicted by either of the parties, and considering the restrictions imposed on free movement of personnel and normal activities, the petitioner could not complete the project in time, are the relevant factors constituting special equities against invocation of bank guarantee. India has a coastline of about 7517 kilometers, providing for a significant opportunity to the shipping industry. The shipping activity is not limited only to ship owners or charterers and involves, as Shubhajit has said, interests of cargo traders, importers and exporters, shipping lines agents, container agents, clearing agents, stevedoros, handling service providers, etc., and the ports, the main person in the entire thing, gamut. The port sector in India, which encompasses both major ports and minor ports, have witnessed considerable volumes of business in the recent decades. The COVID-19 lockdown, an unprecedented event in history, has posed a great challenge to the Indian maritime industry. Vessels are found stranded at ports under quarantine. Cargo movement is facing many logistical constraints. Both the ship owner and the cargo owner are facing problems of their own in performing contracts. It is common experience that one of the parties or the other is seeking to avoid obligations under contracts, whether it is a charter party or a contract of agency or of handling or stevedoring, due to unanticipated problems arising from the lockdown restrictions. In such a scenario, the concepts of contract law having relevance to shipping trade, namely frustration of contracts and avoidance, have assumed great significance. Drafting contracts in any aspect of maritime trade will now require to will now require special technical skills to cope up with the difficulties ushered in by the altered social and business environment. Maritime law envisages different kinds of shipping contracts. It may start with the shipbuilding and ends with the shipbreaking. Now, these shipbuilding agreements, the standard clauses usually finds place in such contracts, provides that intervention of government authorities, labor shortages, plague, epidemics, or clauses like government control, intervention, requirement or interference, epidemics, and any other cause of a similar nature to the above beyond the control of the builder or the subcontractors constitute grounds for postponement in the delivery date. Similarly, the ship sale agreements generally contains exemption clauses by which a seller is relieved from his responsibility to pay compensation to the buyer for losses and expenses for failure to give notice of readiness, but the failure was caused by the matters outside of the seller's reasonable control. This is typical of Singapore sale form. In some other types of agreements such as Nippon Sale 1999 FM clauses are widely drafted that annuls the agreement and exempts either party from liability should the vessel not able to be delivered before the cancelling date through the outbreak of war, the restraint of government, princes of people, political reasons, or any other cause over which the sellers have no control. The contracts of affreightment are discharged by frustration in accordance with the general law of contract, where a change of circumstance subsequent to the formation of the contract results in such a fundamental and radical difference between the circumstances as envisaged by the contract and the parties are released from their bargain. Despite initial hesitation with respect to time charters, it is now clear that no form of charter party is immune from frustration. This is the decision of the Court of Appeal in Bank Line Limited versus Arthur Capel. Similarly, the doctrine was applied to a demise charter in Blaine Steamships Limited versus Minister of Transport, reported in 1951 to KB 965. In principle, a contract of affreightment will be frustrated where performance of the contract has been rendered impossible. Impossibility must be established, in fact, for example, by destruction of the subject matter of the contract or of something essential for the performance of the contract according to its terms. There is, however, no general doctrine of commercial impossibility whereby a party can invoke frustration simply because it has become unexpectedly costly to perform, even to the point where what would have been a profitable contract has been rendered a losing contract. Impossibility may also arise through performance being rendered illegal and maybe by a supervening change in the law or in the law of the place of performance. A contract may also be discharged by frustration of purpose. Of course, the principle that was applicable in such cases may be not much as different from impossibility. The underlying idea is the same. The change of circumstances renders it impossible to perform the contractual bargain. The other important factor is the delay. In delay cases where an event causes delay in performance of contractual obligations, it may be possible to say immediately that the prospective delay is so great that the contract is frustrated. In other situations, however, it may be necessary to wait to see whether the delay has been already occurred and is likely to occur in the future is so great as to frustrate the contract. The supervening event must not be due to the fault of either party, that is to say, it should not be a self-induced frustration. Coming to the charter party agreements, of the agreements that are invoked under the Knipe and Baltine forms, the vessel will be considered off-hire if unable to operate, if they are unable to operate due to deficiency of officers or men. The Knipe allows for off-hire where this is caused by any other cause preventing the full working of the vessel. Under shell time, the vessel will be placed off air where time is lost for the purpose of obtaining medical advice or treatment for or landing any sick or injured person or due to any delay in quarantine. These clauses would seemingly cover situations where a ship is delayed or becomes inoperable due to number of crew becoming unwell due to the virus. While time charter parties require the voyage to be performed with the utmost dispatch, most charter parties would include a clause to allow for a deviation to save a life. In a time charter party, charterers will have an obligation to nominate a safe port, and therefore, where a port has become unsafe due to COVID-19, an alternative port may be nominated. Many charters include reference to Hague-Bisbee rules, which under Article Roman 4, Rule 2H exclude carrier responsibility for loss or damage arising from quarantine restrictions, a useful provision in the current circumstances. The European courts have recognized FM as an irresistible force, one that could not be avoided in the exercise of due diligence. What the carrier must show is more akin to the plea of impossibility of performance of a contract which involves an event which renders a contract not merely more onerous but completely impossible of performance. The event must be one which literally could not be avoided by the carrier. Taking note of drop in export, import, that is EXIM, cargo due to supply chain disruptions on account of COVID-19 pandemic, the all 12 major ports to defer the lease rental and license fee related charges for April, May, and June, besides waiving rentals in proportion to the cargo drop and not to levy penalties. So in conclusion, I would say that FM provisions are interpreted strictly in order to ensure that they are not used unscrupulously by a party in order to evade responsibility. The existence of COVID-19 does not in itself create an automatic force majeure event. It must be causative and directly impede the performance of the obligation due to, say, as I said, port closure, sickness of the crew, shortfall of the crew of the vessel, shipyards are unable to carry out the workings of the repairs, and closure of the shipyards, government restrictions, etc. Therefore, it is not sufficient that the performance of the obligation has become more burdensome or is suddenly more expensive to fulfill. A party claiming FM will have to prove that they have employed the standard of care that is expected from bonus pater familias to fulfill the contract, mitigate losses, and must further prove that they have not contributed to the failure or delay in performance of the obligations. However, the most important factor, as I said, that while referring to the decisions of our court and the English code also, that what would be the situation when a party is with his eyes wide open entered into a contract post COVID-19. So one has to be very careful if a party is seeking to evade its responsibility post COVID-19 contract, and there the difficulties may arise for the party. Thank you for allowing me to give you this introductory lecture. Thank you.
Justice Sen, it was extremely insightful, and we could really learn some important aspects of force majeure and of frustration. I believe what the last point you made is very critical for everybody in audience and for the entire maritime industry, that contracts post the lockdown period and post COVID for the next 2-3 years, anticipating a lot of restrictions coming from government regulations, will have to be drafted and will have to be contracted with special care, keeping in mind the challenges and the constraints that these safety measures are going to bring, that are going to make essential. You also mentioned a drop in shipping activity in India. Just yesterday, the Indian Express had reported an article that major shipping lines like Maersk and APL and a lot of Hyundai shipping lines are avoiding India and skipping India in terms of container trade. So the challenge will be both for the government as well as for the private sector to get the industry back on track, to get the maritime industry booming as it was doing before, and also in doing so to have the contracts and to have the reciprocal obligations agreed between the parties so that the functionings can be done at all stages between all stakeholders. It can be done without any problem. I now request Mr. Tilak Kumar Bose, a barrister and senior advocate of the Calcutta High Court, considered as one of our premier maritime counsel. There is hardly a shipping litigation in the Calcutta High Court in the last 15 years that did not have Mr. Tilak Bose for any of the sides. In one of the sides, Mr. Bose has to feature because he is the most sought after maritime counsel in the Calcutta High Court. And I proudly say this because I have the opportunity to assist him in many of the cases. Mr. Bose, I request you to kindly address our audience of Bengal Chambers on the topic, please.
Right, thank you. Thank you and good evening, everyone. Well, last few months, 3 or 4 months, that must have been disastrous for the shipping industry. Well, some of you at least must be contemplating terminating your contract on the ground of frustration. Now, before you do so, I'd request you to have a look at the doctrine of frustration. How is it applicable to your contract? Because wrongful termination may expose you to huge damages. Doctrine of frustration in India is contained in our section 56, as Justice Sen was saying. It is an ancient act of 1872, based on law which was there in England in 1872. It basically says any supervening event which is impossible or illegal, contract will stand frustrated. English law has moved ahead. You can't now have a contract frustrated, cancelled at the drop of a hat. If a contract is burdensome to you, too bad. If a contract has become economically not viable to you, too bad. That is what English law is about. But then in English law, nowadays, doctrine of frustration you won't find in any shipping contract. Do you find in any shipping contract any clause with the heading frustration? You will find a shipping contract with the heading force majeure. Sometimes force majeure will also not apply in your contract. Now, it may come in the form of exception, hardship, strike clauses, demurrage clauses, ice clauses. But no clause you will find with the heading force frustration, even in Indian contracts. Have you ever found any clause with the heading frustration? Well, hardly ever. But you will find invariably a clause with the heading force majeure. When I say force majeure, I'm talking also of exception, hardship clauses. So doctrine of frustration, when you talk about doctrine of frustration, it has become more or less redundant by incorporation of force majeure clauses in contract. It is force majeure clauses which are more important now. When you look at a contract, you see the force majeure clause. Now, force majeure doctrine, there is nothing called a force majeure doctrine in England. England has a frustration doctrine. Force majeure doctrine exists in France, embodied in French civil code. But invariably, Indian contract, English contract will all have a force majeure clause or a hardship clause or a exception clause or a ice clause, demurrage clause. These are the force majeure clauses. So this fine distinction between Indian doctrine of frustration, English doctrine of frustration, it is no longer relevant. What you look is a force majeure clause in a contract. And both Indian contract, English contract will have a force majeure clause. That is what is important. And you have to construe a force majeure clause in a contract. Force majeure clauses, there are basic elementary construction guidelines. Like force majeure clause, if it appears in the form of exception, you construe it narrowly. If you then, there's a principle of contra proferentum. If there is ambiguity in a clause, you construe against the maker. These are old things. Our force majeure clause is what you should be considering about. So this fine distinction between force majeure clause and doctrine of frustration is no longer relevant. Look at the contract. What does it provide? Does it provide a force majeure clause, exception clause, hardship clause? End of the matter. Now, enough of this distinction between force majeure and frustration. Let us talk its applicability in shipping law. Now, what do you talk about shipping law? When you think about shipping law, you talk about freight, you talk about time charter, you talk about voyage charter, you talk about demurrage, you talk about stevedoring contracts. So let us test each one of these. Take, for example, freight. Why do you pay freight? A shipper pays freight to a ship owner. Ship owner collects freight for transportation of goods from place A to place B and deliver at place B. Now what happens? So the consideration is the delivery. What happens if there is a frustrating event and the goods get lost? Well, if consideration is delivery, ship owner has to refund the freight. Now all this is not pleasing to the ship owner. He has shipped the goods. Why would he want to return the freight? So over the years, ship owner started this new concept of advance freight. Now this is peculiarity in English law. Take, for example, the case of Allison versus Marine Insurance, where advance freight was considered. Consideration of advance freight is shipment, not delivery. If you agree to pay advance freight, freight would be refunded to you because consideration is not delivery, it is shipment. Compare it with the case, the Lorna 1981 Lloyd's report. There also, it was advance freight. But the words were, you had to pay advance freight within 5 days from the date of shipment, that is date of issuance of the bill of lading. Now, Lorna loaded cargo. Lorna sailed. Within 2 or 3 days, Lorna was not to be heard of again. It was lost. So the ship owner demanded, relying on previous case of Allison, give me my freight. You had agreed to pay advance freight within 5 days from date of issuance of bill of lading. Ship owner said, you can't deliver. My 5 days is not over. Within 2 or 3 days, your ship is lost. So why should I pay? Court held in favor of the charterer. No advance freight because ship is lost. So again, the consideration shifted to delivery, not shipment. Now let us test it with the case of demurrage. What happens in the case of demurrage? Now what is demurrage? Demurrage is liquidated sum. Liquidated sum paid by way of damage. Who pays? Usually the charterer. Charterer has overstayed at the port. Maybe delayed loading, maybe delayed discharge. So charterer has to pay this demurrage. Connected with demurrage concept is the concept of lay time. How does lay time begin? Lay time begins when notice of readiness is issued. There is a free shipping period. Free shipping period for loading, free shipping period given by the ship owner for discharge. Within that, you must complete loading, you must complete discharge. If you exceed, then you are in breach, you have to pay demurrage. Now, what happens if there is a frustrating event when the vessel is on demurrage? Well, liability of charterer is absolute, no matter what the frustrating event is. Charterer remains liable, that is the law. Then what happens during process of lading when lay time is counting? The charterer is not at fault. A frustrating event happens. Lot of things may happen. There may be a political dispute. By reason of that, the government may ask, please remove the vessel from the berth while it is loading. Who pays for the delay? Charterer does. Suppose there is bad weather. Say, for example, Amphan. Chairman, Mr. Port Trust is here. Maybe he has decided in one of these cases while loading is going on to shift the vessel. Otherwise, port property would be damaged. So who pays for the delay? Charterer does. Then at times the ship owner may have to remove the vessel for usual operation. Who pays for the delay? Ordinary operation of the ship during the course of loading, the charterer has to pay. The charterer is liable because it's the charterer's responsibility. Now take, for example, other cases, arrest of a vessel. Many times the vessel is on demurrage. The receiver causes arrest of the vessel. And because of arrest of the vessel, cargo cannot be unloaded. Then this consider the case of the Adelpha, for example. In Adelpha, ship was on demurrage. Charterer arrested, the receiver arrested the vessel. Because of the arrest order, the port authorities stopped discharge. The ship remained for 6 months. Question arose, who pays for the demurrage? It was held that the charterer is not responsible for payment of demurrage. He will pay only demurrage up to the date of arrest. After the arrest order, it is because of the act of court that this has happened. Charterer is not responsible. But compared with the recent case, 2012 case, another case called DGM Commodities. What happened there? There was no arrest order. Vessel was on demurrage, but receiver refused to take delivery. And then the Russian government stopped delivery, said no more discharge because receiver is refusing. Another 6 months, the vessel stayed. It was held here in this case that no, charterer is responsible because the receiver, here there is no arrest order. The receiver is agent of the charterer. So you have to consider each case. Then there are clauses in demurrage clauses called reasonable dispatch. Now what do you mean by reasonable dispatch? Someone has to load or unload within a reasonable time. Now usually ship owners use it against the charterer, say you did not use reasonable dispatch, did not load, did not unload. Therefore you are liable for demurrage. Now at times charterer tried to use it against the ship owner. For example, there was a 1985 case which involved of a SKU certificate. I believe it's a stock unit certificate. The vessel tendered notice of readiness. When it tendered notice of readiness, it did not have SKU certificate. Next day, the vessel was ready with the SKU certificate. But charterer still said, when you tendered the notice of readiness, you did not have the SKU certificate. So what happened? So after 5 days, the charterer was prepared to accept the notice of readiness. Why? Because berth was available. So question arose, will the charterer be responsible for this delay? Yes, the charterer is responsible because ship owner acted with reasonable dispatch. Within 1 day, it was ready with the SKU certificate. Then there may be cases when nomination of port has to be done by the charterer. And invariably, you will find when the vessel is ready, the charterer delays in nomination of the port. And probably there are 3 or 4 ports for the purpose of delivery. The ship owner says, which port shall I go? The charterer keeps quiet because probably is not ready with delivery. And the goods are not there, or the cargo is not there, or the person to take delivery is not there, and the ship proceeds to place B. Then again, when it proceeds to B, charterer will say, why did you come to B? You should have gone to A. Now for all this delay, this is the charterer who is liable. Take for example cases like that 1989 case, when the charterer, the ship owner tendered notice of readiness, but did not register it with the port authorities. The next day, the agent received that notice of readiness. The vessel was about to enter, but the port won't let it enter because priority berthing was given to another vessel. So what happened? The charterer said, you did not declare it with the port authorities. You should have declared. Why should we pay for the demurrage? Said, nothing doing. It's charterer's responsibility to arrange for loading, unloading. You should keep track of your vessel when it comes. You should have it registered. Now coming back, you can talk about demurrage. You should see every clause. For example, at times you have invented this GenCon strike clause. In GenCon strike clause, maybe the contract will not get frustrated, but demurrage is reduced to half. It's what you agree, and that is what force majeure clauses are about. Now take for example the various factors which obstruct the shipping trade obstruct performance? Well, if there is destruction of the rest or the ship or destruction of the cargo, that's one example. It will obstruct performance. Then there may be government sanctions, government legislation, obstruction, and most important, inordinate delay. That is what troubles you most. Inordinate delay. Should you terminate? Should you not terminate? With the contract frustrated? Let me deal with briefly with a few of these. Now, take for example the first one, which I told you, destruction of the case res. The traditional case is the Gulness. Involves the Spanish Civil War of 1930s. There was a peculiar clause in the contract. It said, if for any reason the vessel is detained, for any cause arising out of civil war. So people even contemplated a war and included foreseeable event. So there was heavy bombardment. The ship was heavily damaged. Question arose that, are you covered? Is this frustrated? Is contract? Court said, yes, it is frustrated. When you want to exclude frustration, there must be clear-cut words. It's a general words like Spanish Civil War won't do. If you exactly bombardment by reason of Spanish Civil War must have been included. If you want to include in force majeure clause this exception. What happens if the cargo is damaged? Well, there have been many cases. Take for example the case of Zua Maru or the Kawasaki Steel Corporation case. There it was Saudi Arabian oil, general Saudi Arabian oil, 10% shortage. Question arose, will the 10% shortage, it was because of government restriction that there was 10% shortage. Will the 10% shortage be frustrated? Court said no. Look at your charter. Charter says just Saudi Arabian oil. Doesn't pinpoint which storage tank, which person, nothing specified, just Saudi Arabian oil. Take for example the other case, Abyss Ridero, it concerned that warehouse, fire in the warehouse. What happened? The vessel was ready to load. Cargo consisting of bales of wool was stored in the warehouse. There was fire in the warehouse. Half of the goods got burnt. It had only 167 bales of wool remaining. Question arose in that case, that was the charter frustrated? Said certainly not. The charter is for a ship. It may specify a general cargo, not a specified cargo, not pointing out a particular warehouse, not pointing out a particular supplier. It only is general cargo. How can the charter get frustrated? How can contract get frustrated? You have to examine your contract. You have to examine very facts and then come to a decision. Take for example, now let's go to the question of illegality. Now what is illegal? There may be all sorts of illegality. Government restraint orders, a contract may become illegal, therefore performance may become illegal. There may be government restraint orders. Of course, if there are government restraint orders, depending on how long these government restraint orders are there, contract will get frustrated. But what type of restraint orders? Take for example, the case of Brunner versus Webster, an old case. Rice was being shipped from Rangoon for delivery at a port in Romania called Galatz, now Galati. When the ship was in Beirut, government officials said discharge is not possible. In Romania, in Galatz, ship owner believed, sailed all the way to London. Goods were sold in auction, liable for conversion. It was false. There was no Romanian law preventing discharge. You have to check, but de facto restraint don't do. Now let's come to the question of inordinate delay. Now, I believe time is very short, so I'll be summarizing and giving you bullet points on inordinate delay. Now, void charter party, inordinate delay. Usually, I'm not talking about force majeure clause. Force majeure clause may provide something else. I'm talking general principles. So void charter party, inordinate delay, usually contract frustrated. Time charter party depends on the duration. Justice Sen talked about Bank Line versus Keppel, 1913 case. Depends on the duration. 1 year charter party, time charter, frustrated. If it was 5 year charter party, look at Tamplin, Anglo-Mexican company, not frustrated. In Tamplin, it was a 5-year-old charter party. Charter party was 1914. Requisition order came after 2 years. British government requisition, World War I case. British government requisitioned in 1916. When it went to the House of Lords, 9 months of charter were still remaining. Question arose, is the charter party frustrated? Time charter? No, charter party was not frustrated. But as I said, depends on the duration. Like Justice Sen said, Bank Line versus Keppel, that was for 1 year duration. That is why it was frustrated. What about natural calamities? Well, you are talking about the Amphan. Will that frustrate the charter party? Will that frustrate the contract? Well, we have a reported case on neap tides. Natural disaster, delay because of neap tides, charter not frustrated. Amphan. Well, cyclones, if you are so keen to include cyclones in your, why didn't you include it in your force majeure clause? That's what I want to say. A vessel is coming, you people are involved in shipping trade from Singapore to Calcutta. Why include in your contracts something called the ice clause? Is it relevant? If you are so keen to include a cyclone clause, why didn't you include it? So you have to examine the charter party. What about strikes? Depends on the duration. What type of strikes? What is the clause? You have to examine each one of them. Is it a national strike? If it is a national strike, what's the duration of the national strike? Look at the case of Penelope, 1928 Provet Division, coal mine strike of England of 1926. Carried on for 6 months, charter frustrated. So what do you decide? So how long will you wait? You have to wait for some time. Just because there is a strike, there may be sporadic strikes. Strikes are happening every day. But does it mean that the contract will get frustrated? Take, for example, this lockdown. Now, I do not want to go into the question where lockdown is a frustrating event or not. I ask to you all, which is the date? Which is lockdown 1 the date, or lockdown 2 the date, or lockdown 3, 4, 5? Which is the date? How long will you wait before you decide that because of inordinate delay, the contract is liable to be terminated? The law gives you no answer. It's totally unsatisfactory. The principle is wait and see. Wait for some time. Act like a prudent businessman. Then say it is not possible for me. It is not economically viable. Every reasonable person would say that it is not economically viable. So that leads us to the question. So which is the frustrating event? Is delay the frustrating event, or the occurrence which caused the delay the frustrating event? You have to examine these. You have to examine these before you come to a decision to terminate the contract. Remember the facts of the Iran and Iraq war cases of 1980s? Let me give you the facts. And that gave startling answers on the question as to when you can terminate the contract. 1980 Iraq-Iran war. There was no declaration of war ever. From entire month of September, and mark the dates, entire month of September, there were border clashes. On 15th September, the waterway, what is called the Shat al-Arab waterway, was closed. On 20th September, not a single ship could move from the waterway. On 23rd September, Iraq started offensive. On 7th October, Iraq withdrew the offensive. Now, most of these cases went to arbitration, some went to the court. Now, it was a question, when did the charters get frustrated? Well, was it 15th September? Was it 20th September? Was it 23rd September? In none of the cases, it was decided that these were the dates on which charter got frustrated. You would be amazed to know the answers. In 2 cases, the Wenjiang and the Chrysalis, it was held 24th October. Why? Because after 7th October, no ship could move. There was optimism in the air. Every day you thought, just like our lockdown, every day you thought that ship would be able to move, carried on for 2 months. So in Wenjiang and in Chrysalis, 24th November, in a case called the Ivia, 4th October, in a case called Agathon, 17th October. Mind you, in Agathon, the charter was not terminated. The charter was not terminated by any person. The charter was not terminated by any person. Now, the only thing which happened in the Agathon was that the court found that it was 17th October. The contract had stood frustrated. So where do we go before we decide that we should terminate a contract? The principle is wait and see. Wait and see. Just because there is a strike, just because there is a lockdown, just because there is something frustrated, don't take a hasty decision. You have to wait and see. Behave like a prudent businessman. Now let us, I think time is almost over, talk about something about stevedoring contracts. Let us talk something about stevedoring contract. Now, whenever there is a frustrating event, invariably you will find there's a war between the ship owner and the charterer. They will say that the charterer, the stevedor is my servant. No, he's your servant. This is what happens because the charter, most of the damage happens while stowage of cargo. It is in the custody of the ship owner, and just to avoid the responsibility of the cargo, ship owner will try to shift it to the charterer and say, oh, you engaged, you nominated the stevedor, so you are responsible. Take, for example, the New York Exchange Produce Form. New York Exchange Produce Form says that the charterer is responsible for stowage under supervision of the ship owner. Now, ship owner, charterer will say, oh, it is under your supervision, so you are liable. No, not always. Depends on the responsibility of the ship owner. If the word is used that it is under the responsibility of ship owner, certainly ship owner is liable if damage happens. See, for example, the case Agronaut. Then in most cases, ship owner is responsible for supervision of the cargo. Of course, he has to supervise. Otherwise, how will he know whether the ship is seaworthy or not after stowage? But does mere supervision put the fault on the ship owner? No. Mere supervision does not impute fault. But if he interferes too much, yes, he is liable. Then I find a very recent trend which is happening. Every time there is this damage, ship owner will say, oh, charterer, you nominated, therefore you are responsible for the damage, and it is negligence of the stevedores. This is not correct at all. Again, when the damage happens and ship owner cannot accept the responsibility, say that the ship owner or stevedore, you are independent contractor, you are liable. This is not good at all. This is not good shipping practice at all. Of course, the ship owner remains liable. He is vicariously liable. Same with the local agents. If you are listening, some of you, you are all agents of your foreign principals. Frustrating event is happening, and the fight between you people know best what is the ground zero reality. You know whether it is been a really frustrating event or not. But your principals are fighting, said, no, this is not a frustrating event. So all I can advise you, you see how it goes, you advise your principals correctly. You know the ground zero reality. You are the best people to know all this. No, I don't think there is much time. So I will just conclude by saying and asking this question: what has COVID-19 taught us? Well, COVID-19, according to me, has taught us the importance of force majeure clauses. how important these force majeure clauses. If you want to include any event, include it in your contract. Do proper drafting of contract. Not include ICE clauses which are not relevant. Time has come to change your clauses. If you want to include cyclone in the Bay of Bengal, do it. But who will accept, who will agree to it, that I don't know. But if you don't include a foreseeable event, then don't, the court will always say, oh, you did not include it, therefore it is not relevant. You cannot rely it as a ground for frustration. Because frustration of contract, you cannot ask for a drop of a hat. No contract, that's very rare cases. You can't ask for the drop of a hat that every contract is frustrated. Right, thank you. Thank you.
I thank Mr. Tilak Kumar Bose for such an insightful journey into the concepts of the charter party and shipping contracts. What I believe was extremely helpful for the audience was that we shifted the focus from the COVID in entirety and we looked into the basic concepts that become relevant in situations like the pandemic has posed to us now.
I think, if you don't mind, I think you said David was to address on that. That's why I deliberately left it out.
Of course. But these concepts that you have discussed before us today are extremely relevant, and for any draftsman of a charter party or of any of a stevedoring contract or of a shipping contract will have to be more realistic on the circumstances that will govern the transaction and the probabilities and foreseeable events that might come, rather than the usual standard formats that are the rule of the day. That is extremely relevant. One thing I would like to point out to the audience, we have a significant number of audience right now, around 250 people in audience, that if you have any questions for the esteemed panelists, please post the questions on the chat box so that we can place it before the panelists at the end of the event. And the particular distinction between force majeure and frustration, and also their relevance becoming very slim and bleak in times where contracts, specific wordings of a contract, are the most decisive factor. That explanation from you, sir, was very helpful, according to me, for all our members in the audience. I now turn to Mr. David Morris. Mr. David Morris is a partner of Holman Fenwick and of London, and William of London. I'm sorry, I did not complete the name. It's Holman Fenwick William LLP of London. It's an international law firm with several offices across the world. Mr. Morris is in charge of the Indian desk of the law firm. He's based in London. We thank him wholeheartedly for sparing his valuable time and delivering his speech, making an address to our audience, to us this evening. May I request Mr. Morris to please start your presentation.
Yes, of course. Thank you. I've prepared some slides actually, and I don't know whether
I'll just request the Bengal Chamber Technical Committee to please start. I think we have them on the screen. Yes, sir, you may please go ahead.
Okay.
Mr. Morris, good evening. I'm from the Bengal Chamber technical team. You just give me a cue to when to change the slides, it will be done.
Sure. Shall I put my pen in the air every time it's time to change slide? Okay. Well, let's go forward one slide.
Please change, yes.
Okay. So yes, thank you everybody. I'm David Morris, and I'm going to talk about force majeure clauses as a matter of English law, with a particular focus on COVID-19 and how that factors into cases of force majeure. Just a very brief word about myself before I start. I'm a partner in Holman Fenwick's shipping department based in the head office in London. As was just said, I have the great honor of being the head of the India desk at Holman's, which means I'm responsible for the firm's Indian clients. I've had the great pleasure and honor of working with Indian clients for the last 20 years, and I typically visit India 3 times each year for about a week on each occasion to see clients and give seminars and conferences. And I'm recommended for shipping by the 2 leading independent shipping directories, that's Legal 500 and Chambers and Partners. The next slide, please. Can we have the next slide? So a very short word, if I may, just about Holman Fenwick before I get going on the main part of the talk. The firm was established in 1883, so it's been around for the best part of 140 years. It employs 600 lawyers, of which 170 are partners, and the firm has 20 offices around the world. It's been consistently ranked as the leading law firm for both shipping and commodities in Chambers and in Legal 500. And the firm just won the Lloyd's List Global Award for Excellence in Maritime Law. Holman's, I think, is I mean, it really is truly a litigation firm. It is the 2nd most active law firm in the English commercial court, and the most active law firm for arbitration-related litigation. And I think, to my mind, the most important fact for the firm's clientele is that Holman's has one of the very highest win rates of all the cases it fights out of the UK's top 25 law firms. I think over the last 25 years, Holman's has won 73% of the cases it's fought. And that's against an average win rate amongst the UK's top 25 law firms of 60% in the same period. I think as a testament to that the firm is described as the standout firm for commercial litigation by the Lawyer magazine. You can have the next slide. Yes, so COVID-19, the World Health Organization declared the outbreak of COVID-19 a public health emergency back in the end of January. And as Mr. Justice Suman said, the World Health Organization declared it a pandemic on the 11th of March this year. It's fairly striking, actually, when one looks at the statistics now. As of yesterday, there have been more than 7.5 million cases of coronavirus reported across the globe. And that's tragically resulted in more than 420,000 deaths globally. The virus, as we know, is particularly infectious, and it's primarily spread between people during close contact, including by people speaking with one another. If I could have the next slide. Yes, the authorities, as we know only too well, have responded by implementing some what in normal times would be considered extraordinarily draconian measures to try to limit the spread of the pandemic. And those have included implementing travel restrictions, lockdowns, as we had in India, I think until the 2nd of this month, and closures of various factories and other facilities. And so inevitably, the pandemic has already caused a huge amount of social and economic disruption. And it has triggered the largest global recession since the Great Depression of the early 1930s. So it hardly comes as a surprise, I think, that the pandemic and various governments around the world's responses to it have had a really profound effect on parties' abilities to perform their contracts. It's also, of course, made some contracts very significantly less profitable to perform, and that's a topic that's been touched upon in the last 2 speeches, which I'm going to come back to shortly. But the result of all this is that we've seen a huge spate of recent cases where parties are seeking to escape their contracts, or they're seeking to avoid liability under them. And in the vast majority of those cases, they do that by seeking to rely on a force majeure clause contained in that contract. So the next slide. So yes, I thought I'd just begin with a quick summary of what a force majeure clause is. I think it's probably more than familiar now that we've had two excellent speeches about it. But I've put on the slide here a very succinct definition of what a force majeure clause is, or how it's understood as a matter of English law. A force majeure clause describes a contractual term by which a party is entitled either to cancel his contract, or he's excused from performance of the contract, or he's entitled to suspend his performance of the contract upon the happening of a specified event that is beyond his control. We can have the next slide. So force majeure clauses generally seek to strike a fair balance between the contracting parties when something which is very significant happens and which is truly outside their control. And so through case law, I think the following principles have been developed as the applicable principles in any force majeure case, which is dealt with under English law. If I could have the next slide. Yeah, so the first point here is that it is for the party who is seeking to rely on a force majeure clause to prove his case. The burden of proof falls squarely on his shoulders. And he has to show four things, in essence. The first thing he has to show is that a force majeure event has occurred. The second thing that he must show is that the event has prevented him or has hindered him or delayed him from performing his contract. The third is that the prevention or the delay was caused by circumstances which, as I say, were genuinely beyond his control. And the fourth thing that he has to prove is that there were no reasonable steps that he could have taken either to mitigate the force majeure event or to alleviate or mitigate its consequences. So what I want to do now is just run through each of those four questions that one has to ask as a matter of English law, and to see how English law applies and deals with them. So could I have the next slide? Thank you. So yes, the first thing is, I think Mr. Bose was just saying, is that when you have a force majeure situation that arises, the first thing you'll do is to look at your contract and to see whether your force majeure clause contains a provision that covers the event that's happened. Now, in the case of COVID-19, I think specified events such as epidemics or pandemics will clearly cover COVID-19. A very frequently seen force majeure event is act of God. And I think that there have been no decided authorities on this point, but I think the likelihood is that an act of God will cover COVID-19. And I put there in parentheses a possible caveat to that, which is that if it should emerge in due course that the virus was manufactured in some Chinese laboratory, then of course it would not constitute an act of God, but of course I think that's an entirely fanciful proposition. An interesting question, though, I think arises in the context of acts of God. Does an act of God cover the acts of governments taken in response to COVID-19? I can say for certainly in the case of the UK, there's nothing divine about the government that we currently have. And I think that's a serious question, actually. And so important, I think, to look out for provisions such as acts of governments, which will cover a government's responses to COVID-19, such as lockdowns, as we've seen, or closures of ports and things like that. A very useful catch-all provision that one commonly finds in force majeure clauses, which typically comes at the end of a long list of specified events, is any cause beyond either party's control, or similar wording. And wording to that effect will cover, I think, both COVID-19 and government's responses to it. A slight word of warning on that, though. If you have a similar phrase, but it's expressed as any other cause beyond either party's control, the way English law will construe that will be to look at the other clauses that come before it. And so COVID-19 or government's responses to it will only be covered if that really addresses a similar type of clause as those clauses those specified events that are set out in the force majeure. So what I mean by that is if you have just a set of force majeure events which really address breakdowns or mechanical issues with some machinery, that probably wouldn't cover force majeure. It's not a similar type of event. But where you have more natural causes, something like an earthquake, I suppose, or something like that, that's a natural cause, and I think that would then embrace COVID-19 as well. One last word about specified events. The expression force majeure itself, and we've mentioned it, it came from French law, and the term is very well understood as a matter of French law. Important to remember, though, that as a matter of English law, the words force majeure, the expression force majeure is not a term of art. So if you simply have a contract that says if a party can't perform his obligations under a contract due to force majeure, that will not be enforceable as a matter of English law. In English law, that is considered too vague to be enforceable. Force majeure can only be understood if it's contained in a clause that contains other clauses, so that the court can determine the types of force majeure event are intended to be covered. If I could have the next slide. Yes, so a word about notices in force majeure. This is something that one often comes across in force majeure cases. So declarations of force majeure given by third parties, and in a shipping context, that'll typically be ports who will give a declaration of force majeure, don't be lulled into a false sense of security, that automatically means that a force majeure event is in play. A declaration to that effect is simply evidence of what is contained in the force majeure declaration. What really matters is what the parties have agreed, the terms of their force majeure clause. So even if a port declares force majeure, it's important you go and have a look at your force majeure clause and check that it actually covers that whatever the force majeure event, according to the port, is excluded by the terms of your contract. Just while I'm still on the subject of notices, a technical point to be cautious about as well. If a force majeure clause requires a party who wants to rely on force majeure to give written notice to his contractual counterparty of the force majeure event, that will be a condition precedent. And by that I mean that if that affected party fails to give the requisite notice, he will be prevented from relying on the force majeure clause. I have the next slide. So it's not enough to show for the party seeking to escape liability for his contractual obligations, just to show that a force majeure event has occurred. It's a simple matter of contract. He's also got to show that this force majeure event has caused his failure or his inability to perform. And I think perhaps an important point to make here is that where one has, as one often does, concurrent causes of a failure to perform, one of which is covered by a force majeure event in the contract, and the other which is not, the force majeure clause will not apply. So by way of an example of that, let's say we have a vessel which is due to call at a port today on the 13th of June, and a storm prevents her from getting in. Now, the charterer relies on the force majeure clause, which exempts him from liability for delay caused by storms, which all looks fine on paper, but if as a matter of evidence, the charterer doesn't have a cargo ready to load on the 13th of June, indeed he won't have a cargo available for some time, then he can't say that the storm itself has caused any delay. And for that reason, as a matter of causation, he won't be able to show that he can rely on the force majeure and avoid liability for the delay. The next slide. Yes, I wanted just to touch quickly on the meaning of the terms prevent and delay, because these are invariably what a party has got to show that is the effect of the force majeure event. I think delay is pretty self-explanatory, and incidentally, where you see the word hinder, that's equivalent to delay in an English law contract. Where the contract requires a party to show that he's prevented from performing his contract, he's required to show that the force majeure has made it either physically impossible for him to perform, or that it's made it legally impossible to perform his contract. And it's just not good enough for him to show that it's simply more difficult or more onerous or more costly for him to perform. So as I say there, a party can't rely on a force majeure clause if the force majeure event has simply made the contract vastly more costly for him to perform, unless, of course, the clause actually says that he can. Could I have the next slide? Thank you. So one of the things, one of the consequences of the sort of global lockdown has been a huge change in market prices. And it follows from what I've just said that a change in market prices, which has been caused by a force majeure event like COVID-19, even though it may render the performance of a contract entirely uneconomic, will not, as a matter of English law, constitute a force majeure event. And that's made very clear by Lord Lawburn in a case dating back from 1917, Tennants and C.S. Wilson. I'll just read out what Lord Lawburn said. He said, "The argument that a man can be excused from performance of his contract when it becomes commercially impossible seems to me a dangerous contention which ought not to be admitted unless the parties plainly contracted that effect." I thought I'd just give a fairly topical example of this in the context of COVID-19. If Party A has agreed to sell, say, crude oil to Party B, and due to the pandemic, the price of oil has just fallen through the floor, Party A cannot rely on a force majeure clause to excuse a refusal to sell the crude oil to Party B on the basis that performance is going to cause him a considerable loss. That simply won't do. So I think that's an important point to bear in mind, because it's one that parties very often try to rely on when it comes to force majeure. Don't just rely on financial consequences. It won't help. Could I have the next slide? Yeah, so the next thing the party seeking to avoid liability is, can he show that the force majeure event that was truly beyond his control? Now, in most cases, it'll be pretty clear whether a case a case of force majeure was beyond a party's control, and I think that's typically going to be so in the case of COVID-19, unless I suppose you are a government trying to avoid liability to a party, and you are the one who imposed the lockdown. There are some cases, though, where questions can arise as to whether or not a force majeure event truly was beyond a party's control. And I think one of those is in the context of, say, a supplier of goods. Let's say that the supplier of goods has got a number of existing contracts, but as a result of a force majeure event like COVID-19, he doesn't have sufficient goods to fulfill all of his existing contracts, only some of them. So what's the position there? Can he rely on a force majeure in those contracts that he can't fulfill? The answer as a matter of English law is yes, he can. He can rely on his force majeure clause, but to do so, he must show that he's allocated the goods that he has available in a way which the trade that he's dealing in would consider both proper and reasonable. And that's the case even if the force majeure clause that requires him to show that he was prevented from performance. In other words, even though he's chosen to perform, say, 3 contracts, 1, 2, and 3 out of 10 contracts, and he hasn't performed contracts 4 to 10, he can still show that he was prevented by COVID-19 from from performing force clauses, contracts 4 to 10, even though it was his own choice to fulfill just 1 to 3. A couple of just caveats on that, though. The supplier can't justify making an allocation of his goods to customers to whom he simply has a moral commitment to do that. He has to show that he had a legally binding commitment to supply the goods to contracts A, B, and C, or 1, 2, and 3, and not 4 to 10. It also won't be sufficient for him to say, well, I'm trying to benefit from perhaps a rise in market prices and just to allocate all of the goods to those contracts that are going to be the most profitable for him. He's got to do it in a fair and reasonable way. Could I have the next slide? Thank you. Yes, another key element to establishing that you can rely on a force majeure clause is to show that there were no alternative means of performing the contract. If there are alternative means by which a party can perform his obligations, he won't, as a matter of English law, be entitled to rely on his force majeure clause. So to give an example of that, let's say I'm shipping coal to Krishnapatnam, and a force majeure event prevents the vessel carrying the coal from berthing there. So I won't be able to sit off Krishnapatnam and rely on my force majeure clause if I could have redirected the vessel to, say, Vizag. And that's the case even though Vizag is 650 odd nautical miles away from Krishnapatnam. And that I'll then have to arrange to bring the coal back to Krishnapatnam by truck, which is going to incur, of course, considerable expense and cause me significant delay. There is an alternative means of performance, and no matter how commercially unattractive it is, if it exists, then I can't rely on the force majeure clause. Could I have the next slide? It's an interesting gloss on that principle, actually, and this is particularly in a shipping context. Where one has a voyage charter party, once the load and the discharge ports have been nominated, we all know, I'm sure, very well that the nominations once made can't be changed unless both parties agree. It's as if they were written in, that those ports, those nominated ports, were written into the contract on day one. So in the example I've just given of the ship that goes to Krishnapatnam, and she's delayed there because of a force majeure event, I won't be required to send her to Vizag if Krishnapatnam is the nominated port, already the nominated port at the time the force majeure event arises. And the reason for that is that I can say, well, look, I had no contractual obligation to nominate Vizag when the force majeure event occurred. The contract was fixed. The only way we could have agreed to go to Vizag is if the parties agreed to vary the contract. There's no obligation to do that. And so, although one talks about alternative means of performance, one is looking at alternative means of performance within the terms of the contract as it stands. You're not required to vary your contract so that you can perform it. Could I have the next slide? Yes, the last point that I wanted to make it concerns the construction of force majeure clauses. Now, force majeure clauses are essentially exclusion clauses. They enable a party to avoid liability when an event has occurred. So historically, and until very recently, such clauses in English law were construed contra proferentum, which meant that in the event of any ambiguity, the ambiguity would be resolved against the party seeking to rely on the clause. Well, that's no longer the case. Since about 2016, there have been 3 cases actually where the contra proferentum rule has effectively been scrapped. It no longer exists. Contracts are just construed on their wording. But that's not to say that because it's a force majeure, because it's an exclusion clause, that it won't be construed strictly. It will be. So the party whose seeking to rely on a force majeure clause can only do so if he can very clearly bring himself within the terms of the clause. He's seeking to avoid liability or his obligations under the contract. So he's got to show very clearly that he's exempted from doing so. So if, for example, one has a contract which provides that a party will be exempted from liability for delay, say, in loading a cargo as a result of a force majeure event, and the force majeure event simply causes a delay in bringing the cargo, say, from the factory to the quayside, that won't enable the party to avoid liability under his force majeure clause. It'll only, the party will only be able to rely on the force majeure clause if it is the physical act of loading, in other words, putting the cargo on the ship, which is prevented or delayed by the force majeure event. I don't know about the rest of you, but I've got a lot of scribbling all over my my slide here. I don't know if that's a commentary on the quality. Is it possible we could go back one slide? I can't actually see what's underneath the scrolling. Oh, it's on everyone. I don't know what's happened to the.
Please try to solve the snag. These slides are coming with some kind of scribbling. If you can please clean them.
Somebody has, scribbled on the screen. That's what we are understanding. It's from one of the participants. So we're just checking quickly what needs to be done.
Great. Okay, I'm just trying to remember what that point was. It's very, very well scribbled, actually. Let's see, I can.
Our sincere most apologies, sir. To the participants, kindly do not scribble on the screen. There are a lot of people who want to hear and want to see the slides. Kindly don't do this.
Okay. Yes, that's right. It was a point just about late time demurrage, another issue that we've touched upon in the two earlier talks. Important to remember as a matter of English law that if you want to exempt lay time or the running of demurrage, you have to say that explicitly in the contract. Even if you have a provision, a force majeure clause that talks about exemptions for delay, it's almost certain, I think, that unless the contract specifically states that you can avoid liability for the running of lay time or demurrage as a charterer, if your contract doesn't say that, then a force majeure clause is not going to help you. One last point, for which actually I'm rather to blame, is this, that in the absence of very clear words to the contrary, if a force majeure clause is brought into play by a party's own negligence or by his own breach of contract or by his own default, as a matter of construction under English law, it's implicitly construed to mean that a party can't rely on a force majeure clause if it's brought into play by his own negligence or his own default. Could I have the next slide? Yes, and one last point, and I think from what I've just been hearing, that this may actually be a point of deviation between English and Indian law. As a matter of it, it's been a very vexed question, this one. As a matter of English law, if a specified force majeure event is inevitable at the time when the contract is agreed, the question has been, can a party still rely on it to excuse his failure to perform the contract? And I think the short answer to that question now is squarely, yes, he can. It is not the court's responsibility to assist parties if they draft imprudent contracts. If a party said, that he can be exonerated from liability in the event that something inevitable happens, then good for him. And this actually was a point that came up. We were arguing the opposite, I should say, in a case I dealt with a few years ago. It's called the Vine. And that case included a provision that the charterers would not be liable for delay caused by interruptions on the business of the port. And the nominated berth was closed for 1 month for repairs when our ship got there. And those repairs were pre-scheduled. They were already in the pipeline when the charter party was agreed. So it was inevitable that our ship was going to be delayed. So we sought to argue that, and this is in front of the commercial court, we sought to argue that as a matter of construction, the event causing the delay must surely be a fortuitous event, not an event that's preordained. And to try to bolster that argument, we put the question to the court as follows. We said, well, can you imagine or give us an example or examples of what you would consider an interruption to a play in a theatre? And rhetorically, we said, well, one might say an interruption might be somebody falling ill and having to be carried out of the theatre, or perhaps a fire breaking out. But one thing you probably wouldn't say is the interval. And the reason for that is that the interval is something preordained. You know it's going to happen. You want it to happen. So you wouldn't say that the play was interrupted by the interval, we said. The judge unfortunately disagreed with us on that point. He said, no, I think it absolutely would mean the interval. So as a result of that, it is now clear as a matter of English law that even if an event is bound to happen when the contract's agreed, if that event is included in a force majeure clause, a party can still rely on it to avoid liability. I should say that we did go on to win the case in the Vine on other grounds. Could I just then have the last slide, I think, please? We are, yes. I mean, so as I've said, force majeure clauses have taken on considerable importance for parties since the outbreak of coronavirus. They are seldom straightforward for parties to rely on, as we've just seen. You have 4 questions that you need to answer satisfactorily to be able to rely on a force majeure clause. And inevitably, there will be significant factual investigation required. So they're not easy things to get home on. It's also essential, I think, if you want to successfully rely on a force majeure clause, to ensure at the outset that you have worded your clause with considerable care. And I think that was a point made very eloquently by Mr. Bowes. And very important to do so, because as we're seeing now, the financial consequences of failing to do that can be very significant indeed. So I think that's everything I had to say. Thank you very much for listening, particularly on a Saturday. If there are any questions that I or the other panelists can assist with, then please do ask.
Thank you so much, David. It was very informative. I think the slides helped, although with a little snag in between. They were extremely, illustrating the points you made. I believe what we have emerging from this session is the drafting of the force majeure clause is going to be the most crucial aspect of deciding any liability or even entitlement of either of the parties to a transaction. Whether it's in the nature of a pandemic or of a natural calamity or a strike or any other issue that either delays or prevents the performance of the contract. And one other very important point, which David, you did point out, was that expense or suffering of loss is not a good ground for seeking force majeure avoidance on the ground of force majeure. That would not qualify as one. In these days, we find that supply chains of goods and materials, of labor, for even handling agents not finding labor, these are delaying operations of cargo. And sometimes people would say that I'm not getting these laborers coming in. They are not having transport to come in. So how can I perform? But these would not be reasons to avoid a contract or to seek them to be qualifying as force majeure. That, I think, is a very important point that you made there. I would now invite Mr. Vineet Kumar, the chairman of Kolkata Port Trust. Mr. Vineet Kumar has taken charge as chairman of the Kolkata Port Trust on 9th October 2017. Since then, the Calcutta Trust has improved on its performances on cargo handling and of the volume traded significantly. Very important fact that I could learn very recently was that even with the global recession and slowdown, even with the pandemic affecting performances, the Calcutta port has still managed about 3% of growth in the current fiscal. It is less than maybe the previous financial years, but with the conditions that are prevailing today, the restrictions that are prevailing today, registering a growth in any way is a commendable achievement. Mr. Vineet Kumar has held very many administrative posts and responsibilities, and he is now, right now, leading the Calcutta Port activities as chairman. And may I now request Mr. Vineet Kumar to kindly address our audience.
Yeah, thank you very much, Bengal Chamber of Commerce. In fact, it is very enlightening for me to hear all the legal luminaires and understand what force majeure is. We have been just issuing notices of force majeure, not not wary of the fact as to what exactly and how complicated it can be. But yes, I myself got enlightened too much, and it really helped me. I must share with you, when the government issued the order, the finance ministry issued order, I think on 22nd of March, and thereafter an order was issued by the ministry. But thereafter, amongst the various ports, only one port, I think Jawaharlal Nehru Port, has introduced force majeure, and all other ports, there was a meeting, all the port general with the ministry, but somehow there was a view that we should not issue force majeure. Maybe ports might be saddled with some kind of responsibility or liabilities, so it's an uncharted territory we should not enter. But when I interacted with our importers, exporters, there was huge demand from them to issue force majeure, and maybe after a week or so I issued force majeure. So I was also questioned as to why you have issued force majeure. I said, sir, I feel like that I have not been able to perform. There are disruptions. We are not functioning at the full capacity at which we should. So I think it is the right step to take, and we took that step. But now I understand how how critical and how what all consequences it has. But yes, one thing is clear, that it is primarily the contract which matters, and the clauses in the contract which are of paramount importance when a situation of this kind arise. I would be speaking little of the subject of today. It's on about how the shipping sector, the port sector, and logistics is working as of now. What is the situation? We have already been here for around more than 1.5 hours, so I'll just be little brief. See, we all have been in this dichotomous situation, especially the port professionals and the logistics people. On one hand, we have all been asked to stay inside the home, and on the other hand, we being in the essential services, we have been running all along, and also we have been coaxing and our stakeholders also to come in this situation, come out of their houses and do things, be it CHAs, be it shipping lines, everybody, and we have been doing that. So it's a very tricky situation, but somehow I'm very happy to tell all of you that not even for a single day the port was closed. Neither Kolkata nor Haldia was closed even for a single day. Yes, there has been ups and downs, the performance. Some day it was less, some day it was more. But not even for a day, both of the ports, any of the ports was closed. As on today, we are working around 80% of the port capacity. Things are almost normal. And I must compliment the shipping fraternity, all the people associated with the trade in the Calcutta, that the eastern sector trade, and especially the Calcutta trade, has got a very good name among shipping fraternity. This time, all our trade partners have come forward, joined hands with the port, and we have all been, to a great extent, mitigating the problems which our end customers, that is importers or exporters, faced. Still, the effort is on. I just briefly say the shipping industry, as you all know, is facing very tough times. Around 6 lakh containers are out of circuit as of now. They are not moving. They are stable. There are 35% reduction in the shipping calls in the throughput, and there is 50% blank calls. Blank calls means the ships are not just coming because the cargo is not there. There are various reasons. If we see from the Indian perspective, in the initial 2 months, April, May, we had our imports lined up. Imports were coming because they have already been ordered in the previous months, so they were coming. But the exports almost became came down to 15-20% because all the factories and everything was closed inside India. Thereafter, now after 2 months of COVID, the situation has reversed. Factories in India have opened. Exports are now coming out, but imports are now almost zero or very minimal, because in the last 2 months, everybody has shut shop and nobody has contracted. In the shipping trade, if you want to bring something in India from China, you have to probably book it 45 days in advance, or from Europe also, or everywhere. So there have been hardly any contracts done in April or May. So, these months are bad, but due to this imbalance, the shipping fraternity, the shipping lines, the feeder operators are facing a problem, because, there is cargo only on one side. The costs are becoming high. So that's why they are taking out their ships. There are issues of quarantining of ships, which by and large is over now. But the other issues which is now is the crew change. The shipping crew is on board for months together, on 6-7 months. Some of the people are there on 6 to 7 months. Very recently, Government of India came up, with the policy to allow crew change. It is happening now. A lot of ports in the other countries are still not allowing. Even there are charter flights being booked to bring in the ship crew from other countries. But this is all putting strain on the normal shipping operations. The what we understand is that things have started improving with better situation in Europe. Now the corona graph is coming down. The China, we also understand that things are starting to be okay. And I was recently interacting with the importers and exporters. So what we understand that maybe by middle of August, things will start to improve, because things will be booked now. So maybe it will take a couple of months for them to be normal. So hopefully if things remain okay, and in India, we are also able to manage it to some extent, we will be, we hope to be maybe end of August or early September, before Puja, things should start to be okay. That it has many ifs and buts, but still it is there. I would just like to inform that in the year 1920 we have been able to have a profit of around 87 crores before tax and then 32 crores post tax. That is the second consecutive year after a very long spell of 8-10 years that we are in profit. Somehow we have been able to maintain. However, the last part, the month of March and February, were badly affected by the COVID thing, because Calcutta port, our majority of trade is with China and East and Southeast Asian countries. So that's why, but we had an effect, but somehow we have been able to manage. As of now, the trade is down by around 33% on an average in all Indian ports. So it's around 33% down across. Somewhere it is more, somewhere it is less. It is more in container business, less in the bulk. Because in bulk also people are having inventories. The factory was closed for 2 months. So now they still have their raw materials and inventory. So they are not booking anything new. There are issues of labor. Everybody knows that the labor has now gone back to their villages. It will take a while to bring all of them back. Luckily, in our port, most of the labor is local, so we do not have that issue. But I must tell you that we had a very, it is a very life experience for life for all of us in the port, because the biggest challenge with us is other people can work from home. We are an industry which cannot work from home. The people have to go on the ship, operate. People have to operate trucks. People have to operate cranes, trucks, trailers, everything. Now when so many cases are happening, and we till now have had 56 cases in Port Trust. Luckily, none of our employees or contractual employees or anybody has lost life, and we have been successfully able to treat them in our own hospital. Around half of them are already well and have gone back to their houses. But in the labor, if somebody contracts COVID, the impact is immediate. The people, there is immediate fear among his colleagues as to they are working together, staying at the same place. So that is where we face the biggest challenge. We took massive steps. We made it mandatory to wear masks, gloves in the port, massive sanitization. scanning of everybody. In fact, we had to send our medical team, my team of doctors. They used to go every morning and every afternoon. There was a group of around 25 of our staff who used to work together. 4 of them got COVID. Now all 21 were, there was an option for us to quarantine all 21 of them. But our team of doctors went, they examined them, they had interaction with each one of them. And for at least 10 days, every morning and every afternoon, a team of doctors would go check all of them, assure them that you're all right, keep working. There are separate, different kind of things have come up. There are social issues. People who went back to their homes, their societies will not allow to come out, that, you are going into the port, foreign ships are coming there, you are interacting with the foreigners, so you might get COVID. So they are not allowing, these societies were not permitting people to come back. We have to, we have to issue certificates to them. Our doctors would examine them, issue a certificate, and then they will go to their villages or to societies, show those certificates that, yes, I have been tested by a doctor, I am okay, please allow me to go. So, these kind of social issues also came up. There was a big issue of, if somebody loses life, what is to be done? We spoke to our ministry, and for everyone, whether he is an officer or a staff, we have declared an ex gratia of 50 lakh rupees. So if any of our staff while working loses his life, not only our staff, if people whom we have contracted for working, also our contractors people, because most of the work is being done now through contracting. So the contractor staff who are also working in the port, so we gave them an assurance, okay, if anything happens, we will pay you 50 lakh rupees, the next gratia we announced. So that gave a lot of confidence among the people that the management is taking care of us. So that's how they continued. We made videos of our own staff who are working. A lot of, we went on TV, we went on radio, everywhere we went, and, we made arrangements for people's transport, their stay, their food, everything. We equipped our hospital. My hospital as on date has around 35 beds, fully equipped with all this oxygen and everything. And we have a couple of 6 ventilators with us. We have our own quarantine center where we can keep 30, 40 people. So all that, and luckily it came to our rescue when things went bad. We have to keep at least 10 people in quarantine, 10, 20 in the hospital. But with these, efforts, the staff or the stakeholders had that confidence. Yes, if I am working, something happens to me, I will be taken care of. So with that, we have been, to a great extent, our officers went themselves to see, to visit as to what precautions we are taken. We made committees of officers. They visited every day, twice, to see whether all these things which we are legislated, whether they are happening or not, whether we are providing them masks, whether they are available or not. So all these things, somehow we have been able to do and pass through this crisis to, quite satisfactorily. Equally important with the port is the port related, all port related people, be it shipping lines, CFS, CHAs. They had a very important role, because unless the CHAs come and they clear the cargo, nothing can happen. We got the cargo piled up everywhere. Now we requested our CHAs. We had this kind of web meetings with them. Even during the peak crisis, I may not say the peak of the crisis. I don't know where and when will be the peak. But yes, when we were in the beginning of the this lockdown period, when everybody was afraid, at that point of time also they came out. We also, tried doing a lot of things to make things online, so that, there is no need for them to come, to minimize the human interface. All our RFID permits, payments for renewal have been made online. Customs also did a lot of things. A lot of papers have been made online. We are still, maybe by next week, in the export process, we are coming up with our software modification that almost for the export process, the entire paperwork will be online. So there will be minimum human contact. People need not visit the port offices for most of the work. So that we are on to that. At national level, the government is looking for a national logistics portal. The national logistics portal will not only be covering the shipping area, but will also have the forward and backward integration of land, logistics as well as air logistics. So everything, it will be sort of a marketplace. Already work has started on this. Maybe it will take maybe a year for this to come. The PCX1X module, which is already there on the ports, is being upgraded, and things are latched onto that. A very important document for shipping is the bill of lading. It's a negotiable instrument, which I understand, and the government is in the advanced stage of digitizing that. Right from the shipper, maybe sitting in some other country, the entire movement of the bill of lading will be on the blockchain technology, and it will pass hands safely from shippers to whosoever are there in the chain. So likewise, other documents is also being tried. Port is implementing ERP. So the effort is on, to maybe because of the efforts were on for doing all this digitization for a long time, but maybe because of the COVID, the things got hastened up. This is maybe a positive side of this. And this bill of lading thing, it requires the concurrence of the Ministry of Commerce. So the proposal from Ministry of Shipping has already gone to the Ministry of Commerce. And I understand that a company called Cargo X has already tied up with the Indian firm for providing this facility of blockchain technology, where this thing will be transferred. Once this happens, it will see a sea change in the way we work. The reduction in the transaction times and all this will happen. Despite all this, we all are feeling the around 1 million drivers have gone back to their villages in the country. Now there is shortage of drivers, so trucks are not available. Movement is getting affected. The truck owners or the big transporter, they are sending buses to the villages of the drivers to get them back, but not very sure how early they will come back. But still, everybody is trying, and in this situation, unprecedented situation, trying to find all these different solutions. But hopefully, what we see is that it will take maybe another 3 to 4 months for the situation to normalize. If we see the COVID cycle, it takes around 4 to 5 months starting to the peaking of the graph and then coming down. It is around 4 to 5 months. We have already passed around 2.5 months, or rather 3 months, something like that. Maybe another 2.5 months or 3 months, we will be done away with COVID, and also by that time, industry will also be up. What we are doing and what we think for future is important, or lessons we have learned is, for us, the main important thing now is to take care of our human resource, because once we are out of this after 3 months or 4 months, it is very important that we take care of our human resource now, be it paying their salaries. We have paid salaries to everybody, even our contractual employees, contract employees, everybody, because whether they have been able to come to office or not, because it is very important, not only from the humanitarian ground, but also from the productivity ground, to take care of them now, so that when things are okay, after 3 months, they are up and running and they are to support us. So that's very important. We are working on that. Digital things which we are doing now is something which probably we wanted to do for a very long time, but because of normal way of doing things, we were just doing them now. Because of this COVID pressure, things are happening. So, and more such things are happening, and it will simplify, maybe take away the ills which have been in the industry for a very long time. So all these manual processes will go away. So it will be very, very maybe this situation has created this kind of an impact, and we assure, and we also understand from the government that government is also very keen to continue doing these reforms and stay onto it. Another opportunity in this times which is coming is the effort of the government to bring the industries into India, and ports being the a point where the multimodal logistics is available are ideal for the setting up of the industry. Calcutta port has in land both in Calcutta as well as Haldia and we are making all efforts to invite industry to come and set up base here. The Government of India is, as far as ports are concerned, we are formulating a land policy which will be much industrial friendly than the present land policy. So this policy is in the advanced stage. In fact, it has been finalized by the port chairman and the committee. It is in the there are a couple of rounds which we have had with the discussion with the ministry also. Now it is maybe if things go on track, maybe a month is a time when we can have this land policy, and it's quite friendly, and it gives a different kind of outlook to the entire process of land. It is more not based on the land revenue, more based on the cargo throughput and the revenue from the cargo, and also investment-based decision making. If the investment is large, probably we can give you land at a specified price. So things like that are happening. We are doing an marketing effort also. The Government of India is also doing. So that is one opportunity which we are also working on. All the ports in the country are working on, and we'll also, because all the people from trade and industry are there, I like them also to keep a watch on this, and we can definitely get some good industries to come to West Bengal, which has all everything, good water, land, everything is available. Last point I would like to make that we had a long discussion of force majeure, contract frustration, and everything. In my practical experience in the last 1.5 months have been that every day I have been getting 3 or 4 complaints, like shipping line complaining against the importer complaining against the shipping line, something like that. We have informally, why we do not have any formal control over them, but we, because of our position or because of our being a key stakeholder, we have been forwarding one complaint to another, and making sort of them to communicate and come to a settlement. And I can say that it is the maturity of the Calcutta trade which they have shown, all our stakeholders at this point of time, that almost 90% of the dispute got resolved. 90% got resolved. I hardly find there are a couple of cases here and there, but mostly, people sat together or they discussed, and okay, so much is the damage amount. Somebody reduced it to half to 25%. So either way, they got it settled. This is the time where the industry, the shipping industry, should do hand holding of each other. What happens, that I've seen, the moment we are after a crisis or just the crisis over, everybody start thinking of himself. Why should I leave my money? Why should, I pay him more? That feeling comes. It is a time when, all of us should understand that everybody is passing through a tough time. If there is a loss, let's, distribute it. If you take it half, I take it half, something like that. If we have that approach, probably, we will be much better. And it is required to face this kind of situation. That is the only solution. We have, of course, there are cases where there will be no solution. We have to go for litigation, and we got adequately enlightened on that. One more issue I like our maybe Justice Sen or Mr. Bose can tell is adjudication, sir. If that will help in this kind of situation, you can always we can always go for adjudication kind of thing, or conciliation. If there's, means it's an informal way of doing, solving these disputes. So whether that will be another area to look into. And one more last thing, sir, we are already relate that whatever COVID has negative impacts, one impact is it has given us clean air, clean water, things like that. We must remember that, we have to change our ways of living. And so that we at least maintain all these things. So with this positive note, I'll thank Bengal Chamber of Commerce, Mr. Majumdar, and I'll pay my regards to Justice Sen, Mr. Tilak Bose, and David from abroad. Thank you very much for giving me this opportunity. Thank you, sir.
Mr. Kumar, it was extremely insightful and it was helpful. I just take a cue from where you concluded that it is a time for hand-holding and maybe to avoid long-drawn litigation where it can be. The Calcutta High Court and the Bengal Chambers, they are all encouraging mediation, commercial mediation,
mediation
to a great extent. So
I couldn't get that
wherever
great word in
possible,
my mind, it was actually mediation. I said conciliation.
yes. So mediation can be a real avenue for alternative dispute resolution, and Justice Sen has been, encouraging mediation from the Calcutta High Court to a great extent. We don't have time; we have slightly overshot our schedule time, but I'll just because we have had a tremendous response from the audience. Which has been encouraging numbers also. I'll just take one question for each of the panelists because we have had many. I'll selected just one question for each of the panelists.
Ajit, may I just interrupt for a second?
Please,
for the information of the entire delegates and the speakers, apart from the good things that we are all going to say, Sir, Bengal Chamber of Commerce and Industry has a full department on mediation. And that was also, Victor Moses has been one of the persons who have done this. So that's an information to all. If there's a problem, a dispute, the Chamber is there ready to help. Over to you, Shubhajit.
Yes, even like my firm, my own firm, Victor Moses, where we have 6 partners and a team of associates. Our main the first initiative is to avoid litigation in the sense that if it can be settled by some arrangement of the parties, it would be definitely a more better and commercial way, and it's more prudent for the industry. And only where the dispute is such that it involves a legal question to be decided by court, that it should come to litigation. I'll just take one question each, and I'll start with Mr. Bose. I have this very interesting question. I think this is Mr. Bose is the best person to answer this. If a vessel comes in with cargo and while it is about to reach the port or just near the anchorage, and at such a time there is a government restriction or a pandemic situation by which the port restricts entry to berth or declares force majeure officially, and even the importer declares force majeure and says that I am unable to, an importer being the charterer also in this case, to bring in the vessel at that time. The vessel in any event is waiting with cargo or just about to reach port with cargo. How to resolve or address such a situation and how to pay liability?
Well, contract is definitely frustrated because lay time has not commenced. So far as the charterer is concerned, there is a port which is preventing entry of the vessel. Port is government is preventing entry of the vessel. The lay time, that's for sure. Now the question is whether the charter has stood frustrated or not. Well, you have to wait and see. I told you it's the same principle as strike.
Yes.
Assume that the port is on strike. Port is on strike or something. It's a wait and see principle. You do not frustrate the charter immediately. If there is nothing specified in the contract, it is similar to strike clause. Wait and see. Wait for a reasonable period, like depending on how long this goes on. I told you the case of Penelope, it was national coal mine strike, went for 6 months, frustrated. You have to wait and see. Wait for a reasonable period. That's what you should do.
Right.
But demurrage will definitely not occur.
I think that squarely answers the query on this. I'll just ask David one quick question. It has 2 parts. When do you think a force majeure should be declared by the party affected, whose performance is affected, on the happening of the event, or when the performance is called for? This is one part of the question, the timing of declaring force majeure. And the other one is that if a set of cargo is abandoned by the receiver on arrival of the cargo, either at port or on landing thereof, by reason of a force majeure event, if there is abandonment of, what is the remedy for a ship owner in that situation?
So the first part of the question is when should force majeure be declared? The answer, I think, is it doesn't matter. And if the contract requires you to declare force majeure within a certain time, then it'll tell you what the trigger event is for that time starting to run, or it should do. And you should then declare it within that time. But subject to what the terms of the contract say, there's no requirement in English law that you declare force majeure or that you declare it in any particular time. And you can just say nothing at all, and then when your counterparty comes to enforce against you, you can simply say, well, I don't accept that I'm liable because the force majeure clause protects me. So yeah, unless there's a requirement in the contract that states that you have to declare force majeure in order to rely on the clause, it simply doesn't matter. You can do it, but you don't have to. The second part of the question is if cargo is abandoned by a receiver, that's because of a force majeure event. What's the ship owner's remedy? So this would be an issue that would arise under a bill of lading, and if it would be unusual for a force majeure clause to excuse a receiver from his obligation to take the cargo off the vessel. I think, if it does, that would be highly unusual, and the ship owner then would be in some difficulty. But he should also look at his charter party, because the charter party will also have it's a separate contract with his charterer, and it should also have a requirement. The charterer has to take the cargo off the ship, and if it's a voyage charter, the lay time and demurrage will run. If it's a time charter, the vessel will remain on hire until the vessel's redelivered. So he is not entirely without recourse, even if the bill of lading contract highly unusually says that the shipper just doesn't even have to take the cargo off the vessel because of a force majeure event. He may still be able to fall back on his charter party. If, as I say, it's a situation I have never seen any contract that I've looked at. I've seen quite a few shipping contracts. Both the charter party and the contract of carriage obviate the need for a shipper and a charterer to take the cargo off the vessel in the event or on the occurrence of a force majeure event. Well, that's what the contract says. So the owner, I suppose, but then if the cargo is abandoned, I suppose you'd have to look for alternative orders if the cargo isn't abandoned. But if it's truly abandoned, then he would have to take it somewhere else and discharge it there himself at his own cost.
Right. I believe this comprehensively addresses the situation, and it will largely depend on the actual wordings of the contract that binds the parties as to how they will deal with it. I have just a question for Mr. Vineet Kumar. Sir, I will also have this question in two parts. The first one is, when the Calcutta port declares a force majeure by notification, is it restricted only to the demurrage or the charges that the Calcutta port would be asking from the port user, the service user, or the force majeure declaration or the notification is also intended to bind the ship owner and the receiver of cargo who are using the services of port at that particular point of time? And the second part of my question will be that you've already answered this. How would the Calcutta port manage its filings and how far it will do the filings and works electronically in the days to come to avoid physical contact? But the first part of my question is, to what extent the port notifications on force majeure apply to the private users, intersay their relationships?
Yes, of course, the force majeure applies to the users, the primary users being the, as you said, the charterers with regards to demurrage payments. so that it applies to them. Very well, it applies to them because the basic idea of force majeure was for that only. So it applies to that. As I saw in the David's presentation, that declaration by a port is sort of an evidence. The contract is between the two parties, but if somebody evokes force majeure, he has to substantiate it. Probably what our declaration means is the substantiation of that fact that yes, force majeure is there. So to my understanding and knowledge, yes, it applies to them. That is one. Now, just to come to your second part about the filings and work on e-platforms. See, we are already implementing ERP and other things wherein the, in fact, we were to onto that platform by this month only, but because of this COVID, it got delayed. But in the meanwhile, on our old system itself, we are modifying the system. The export processes we will be able to do immediately. When I say immediately, maybe in the next week's time. Payments, we are trying to make all the payments on digital mode. And we are also talking to some company wherein the we are bringing in a software which is being used in the other states, so that that also will take a large part of the transactions onto the e-platform. But to be very frank, to be fully on e-platform, it will take us at least 4 or 5 more months.
We are extremely out of time, but I still have one last question. It has just come in, and I feel it's so interesting that I should put it before Mr. Bose, because this is very relevant to the address he has made us before us today. Mr. Bose, if the port infrastructure is working with limited resources, and it is not a complete lockdown, it is not a complete closure, but it is working partially, maybe on 25% or 30% capacity, and it results, it triggers a lot of delay. The vessel keeps waiting, and the charterer said it's not my fault because of the pandemic situations. There has been a 15-day, 16-day delay, which is beyond anybody's control. It is beyond my reasonable control to avoid, because the port is only working with 25%. Would it still be a situation which is covered by an act of either impossibility or an act of under a covenant under the force majeure, so as to avoid demurrage in such a situation?
Well, firstly, Vineet has given you the answer. Vineet has said 80% port was working. So you can't say that the port was not working. Now too, you have to look at the clause. But basically, if you ask me, my personal opinion is no, it is not a frustrating event.
Right. I totally concur on that. With this, we come to the end of the session, and I request Mr. Hazara to kindly conclude the proceedings.
Thank you. Thank you very much, Shubhajit. It's my pleasure and privilege to propose a vote of thanks on behalf of the Bengal Chamber of Commerce and particularly the Shipping Committee. At the outset, I would like to first thank Justice Showman Shen, the Honorable Judge of the High Court of Kolkata, for his very, very lucid and informative keynote address. He really told us not only about the historical background of force majeure, giving so many examples, but I think he, and then subsequently, of course, the next speaker, also a wonderful speech by Mr. Tilak Kumar Bose, the bar at law and the senior counsel of the High Court of Kolkata. They also made the distinction between the doctrine of frustration and force majeure. And Mr. Bose particularly gave so many case laws. After all, case laws are the foundation block of the jurisprudence and legal system of any country. So obviously, through so many case laws, Mr. Bose highlighted how the force majeure events actually are to be dealt with, and how it is completely different on case-to-case basis depending on the circumstances. Then I also thank David Morris, who has been a senior partner of Coleman Fenwick, HFW. His former colleague, Hugh Brown, remains a very, very good friend of mine for last few decades. And I definitely think that in terms of the English law,
David made a wonderful presentation of force majeure and covered it in its entirety, again giving so many case laws and so many very nice examples. The chairman of Kolkata Port Trust, Vinit Kumar, we are so very thankful to him, despite his very busy schedule and despite the challenges that he is facing as the chairman of a very, very important port in the country during this pandemic. He has spared his very valuable time and has enlightened us, not only by giving the wonderful news that after a long time, which particularly for people from this part of the country gives a lot of pleasure, that Calcutta Port has turned around, and Kolkata Port definitely has been making profits over the last couple of years, bucking the trend for the previous decade or so. So this is a very good news. And after all, in terms of the government's Look East Act policy, it's only fair that the ports in the East Coast, and Kolkata has been a major primary gateway for the entire Eastern India for a long, long time. And obviously the India's import and exports with its Eastern neighbors and with generally, not only the Southeast Asia, but the entire Eastern world is developing at a much, much faster pace than the exempt trade of India with the West. So it is only natural, and it is desirable that such an important gateway like Kolkata Port gains further significance and goes forward. Of course, I must also thank Shubhajit, because as the chairman of our committee, Captain Sujit Majumdar, has mentioned that this webinar has been primarily his brainchild, and he has tremendously helped the committee and all of us in organizing this seminar. I must also acknowledge the thank of my very good friend Kumar, who of course is again the son of my very, very dear late friend Venki V. Subramaniam, in helping us by giving his support for this webinar. I must also thank, of course, Romit and his team of Bengal Chamber of Commerce. Definitely, they have worked very hard in bringing this webinar to its fruition. And I would also thank all the delegates and participants. We are actually, we must say that we are owing them an apology, because so many of their questions raised, we have not been able to put it across to the panelists. I'm sure, but for the limitation of time, we would have been further enlightened by those questions being put up to the panelists. I would request Romit and his team to definitely chart those questions, and with the help of Shubhajit, to put it across to the concerned panelists, so that the answer can again be given back by mail to the respective questioners who have put these questions. Finally, I, on my behalf, must mention that we, the global citizens, owe a large debt of gratitude to all the frontline logistics players, and particularly the seafarers, by their sheer personal sacrifices and personal hardship. They have maintained a lifeline of supply of essential items to the global citizens all across the globe, but for which the economy has been, of course, affected very badly due to pandemic. But we really shudder to think that if those lifelines would not have been maintained by the shipping industry, what would have happened to the world? So I think we owe a large debt of gratitude to all of them. And I think it is the shipping and maritime industry which, to a certain extent at least, has helped the humanity to fight the COVID-19 in its current form. We can only hope and pray to God that there are no second waves coming in the various countries, including India, because as it is, India is now only peaking. Every day we have this bad news of 11,000 plus new infections and 300 plus deaths. So we can only hope that going forward, they are controlled. We can only hope, as Vineet has said, that by end of August or by September, we are hoping for normalcy. course, the shipping industry has already suffered so tremendously, particularly as he has rightly said, there are, there are hundreds of blank sailings by the particularly container carriers for 2020, whereas the entire, global economy is going to be affected to the extent of maybe 3%, at least 3 to 5% reduction in GDP. The seaborne trade will suffer maybe equally about 3 to 5%, but the containerized trade will suffer to the extent of 10 to 15%. So it is the container segment which has been affected the most. Even the dry bulk has crashed for a different reason altogether, particularly the storage onshore. The tanker segment has been benefited. So far it has been holding good, but the rates are already coming down in tankers as well. And they may not remain very high for a long time. The offshore segment, because of the crash of crude oil price, is also likely to suffer going forward. So overall, I don't think it's a good news for the shipping industry, but we have to wait and see how this COVID-19 pans out. Some people talk about post-COVID. I don't think we are in a position to talk of post-COVID at all, because as per all available indication, the COVID is going to stay for a long time. And of course, with the vaccination being developed, with the medication being improved, possibly we'll be able to contain the pandemic in its present form going forward in a few months. So hoping that the world economy, the world trade, and the shipping do not suffer very much more for a prolonged period, and praying for the same. I think on behalf of the chamber, we can conclude this evening. Thank you, everyone.
Well done. Thank you. I think we can, Romit, you can take over and we can conclude the session. I think everybody has had their say. Mr. Hazra, very well summed up, and thanks to everybody. Especially thanks to the visitors, especially Mr. David Morrison. I think you're in time for an early dinner. So I think we can call it a day, and we'll try and make a similar program, because the kind of messages that have been coming on chat, it appears that people are quite interested in the kind of program that we have held today, the webinar. Perhaps in future, the shipping committee can look for further such programs for the benefit of the trade and industry. Thank you.
Thank you so much, everybody.
Romit, you can conclude. All right, gentlemen, good night, good evening. I suppose we can all quit.
Yes, we can all manually leave meeting. We select the option of leave meeting. Thank you so much.
Justice Sen as well. Thank you so much for being with us. We're very honored to have you.
It has been a great pleasure to have everyone in the panel, and particularly for such an insightful and informative keynote address. Thank you so much.
Sir, thank you so much, all of you, sir. Thank you, Captain. Thank you. Thank you, sir. Thank you, Shubhajit. And thank you to all speakers.
Thank you so much. Thank you.
And I think we had a great session, our third edition of the annual shipping workshop.
Yes, while people are leaving, we still have more than 100 participants right here.
Yes, exactly.
So it speaks of how well taken it has been.
And Captain sir, with all your support, Mr. Hazra sir, with all your support, the entire committee support, particularly Shubhajit, with all your support, we could have this webinar done in this kind of a crisis situation, and we hope to take it forward. And after the webinar, and post-webinar, we're going to make the proceedings and forward it to the committee, and upon the approval of the committee, we'll take it forward to the entire stakeholders.
Thank you. Thank you. All right.
With all this, I thank you once again, all of you, and have a good weekend.
Thank you.
Thank you. Thank you, everyone. Thank you.
Over and out.